file 25-9167AL. And we've got Ms. Sagalovich representing herself today. I have reviewed you filed an appeal, and I've reviewed the appeal record and the transcript and order of the Secretary of State. Is there anything that you want to tell me, Ms. Sagalovich, about your appeal?
Well, Your Honor, my hearing with the Secretary of State was October 10th, 2025. I was denied, not certain the reason. I don't get really much clarity from the transcripts as to why. So here I am today in front of you to appeal that.
All right, thank you. And you can sit down if you want. Ms. Goodrich, any position of the Secretary?
Your Honor, on behalf of the Secretary of State, it looks like the finding was that that she didn't meet the burden of proof of maintaining 12 consecutive months of sobriety outside of a controlled environment. So being that it was while she was on probation, I believe that's why she was denied.
All right, thank you. Well, the Secretary of State commonly uses this rationale that sobriety that occurs while somebody is on supervision from a court somehow doesn't count or should be discounted. And I mean, I suppose there may be, that's not a completely irrelevant fact. There may be a set of circumstances where, you know, let's say somebody's got a 20-year history of substance abuse and they've been a year on probation and a year sober, but in the past they've had all sorts of relapse history. I mean, maybe that's something that they can consider case by case. I'm not saying it's entirely irrelevant, but the way the Secretary of State treated it in this case was to completely discount the time that Ms. Sagalovich had of sobriety while she was in not just regular probation, but a specialized probation of a treatment court program from which she has successfully graduated. It seems to me that there's a lot wrong with the Secretary of State's position. That number one, it discounts the effort of the individual by assuming that they're only sober because they're on probation. Well, I've got news for the Secretary of State. Plenty of my probationers don't remain sober. Although it might make sense to discount forced sobriety for people in jail, being on probation is not forced sobriety. It is still a choice. It is still a chosen path that people take to abstain and get on a path of recovery. I wish that probation resulted in forced sobriety, but it just doesn't. So I think it's factually just wrong to discount that. Secondly, the Secretary of State says, well, they want to see what you can do without the guardrails or the structure of probation. Well, that's, in my mind, pretty rich, because that contradicts the Secretary of State's consistent approach that we want you to have structure in your life to maintain your recovery, like going to AAs. And they routinely say that this sort of lone wolf sobriety is a bad plan, that you need structure. And so for them to then discount the structure that you were provided by a treatment court seems contradictory. And also, probation, especially the specialized probation services like a treatment court program, gives participants a set of tools to help them with long-term recovery, and discounting the sobriety they achieve during those programs ignores the fact that successful participation in a treatment court is a strong indicator of stable recovery. In fact, in study after study and Michigan's own court data repeatedly shows that recidivism rates are significantly lower among people who have graduated from treatment courts. So I do think that the hearing officer in this case entirely discounting Ms. Sagalovich's sobriety time while she was in a treatment court was an abuse of discretion, and that their decision was not supported by competent material and substantial evidence on the whole record. Therefore, I would enter an order that I guess the court will prepare the order. You don't have a proposed order today, do you, granting that? And I know there's some technicalities to that order. We'll go ahead and the court will prepare an order and granting the petition and directing the Secretary of State to issue full driving privileges to Ms. Sagalovich. So we'll enter that order and send that out to everybody, okay? There's a process for that. That doesn't mean you can drive today. So that's got to get sent out. The Secretary of State's got it. You might have to pay a reinstatement fee, all that stuff. Okay. All right. Good luck to you, Denise.
Thank you, Your Honor.
Then let's call Rabber v. Secretary of State.
Good afternoon, Your Honor. Luke Custody on behalf of Mr. Rabber.
Got Mr. Rich here on behalf of the Secretary. And Mr. Kukuski, I've reviewed your petition and your motion and the brief and the record in this case. Anything you want to say in support of your appeal?
Well, quite frankly, Your Honor, maybe just the word ditto would suffice in this matter, because Mr. Rabber was denied any relief in his hearing that we had with Secretary of State because of the same reasons. The Secretary of State hearing officer found that he has not had a term of sobriety outside of any structured court or probation. Mr. Rabber was successfully completed his treatment court with Your Honor. He had a restriction in his vehicle during that
Can I
course.
ask you, I was confused a little bit by this record. He had a restricted license issued through the treatment court program. Is that right?
That's my understanding.
And then he
yes.
goes to the Secretary of State asking to get full driving privileges. Is that
Yes.
right? And he left there with a revoked license?
With no license.
Oh.
They said they had miscalculated when he was in the treatment court, the number of convictions.
Yeah, number of DUIs, yeah.
He didn't have enough to qualify for remaining on that restriction. So, boy, if his conduct would have been worse, he might have stayed on those restrictions, but they actually revoked his license at that time. And this time they completely denied him any relief to get the restrictions. And again, Your Honor.
I mean, even if we were wrong, even if there had been some miscalculation and the Secretary of State had wrongly told us he was eligible for the restricted when we gave it to them, at that hearing, they would have had the discretion and the lawful authority, would they not, to have issued him the restricted license?
Yes, they would. Yes.
Did they explain why they didn't do that?
Well, the hearing officer in the order that I received after the hearing just simply states that there's not enough term of sobriety outside of a structured court or a sobriety court or treatment court or probation that he's been on. That's what I took from the order. There wasn't anything else. I mean, the hearing officer actually agreed that he's been sober for the required time, that he had a prognosis from his assessment and sustained full remission for any of his substance abuses, that he had attended AA, that he had completed everything that he was required to do, even when he had the system in his car, the blow and go, the restriction. He didn't have any violations with that. He had no violations with the court. I mean, we're going on almost 2 years, 3 years here, that he's had it. And that was a surprise to me, Your Honor, that there was no relief given, that he wouldn't just be getting back on the restrictions, because if that was the case, I couldn't have appealed this because he would have been granted some relief. And so here we are with the same issues that was just the case before us. Mr. Rabber has shown an exemplary effort to remain sober. He's completed everything he's been required to do. He's attended EAAs. He's had great assessment. He had great letters of sobriety. And I guess you could read my brief and you could take what you need from that. But I read the statute several times, and in the statute, it just says 12 months minimal abstinence from any alcohol or substance abuse treatment or
The
use.
statute doesn't say 12 non-probation months.
It does not. It does not say outside of a court's oversight or outside of any sort of oversight by the court. So I think the hearing officer and what
Oh,
Secretary
yeah,
of State.
you said that. The governing law does not indicate that a person must demonstrate a minimum period of 12 months of sobriety outside of any court monitoring. That's at page 6 of your book.
Yes, Your Honor. And so they're setting a new standard essentially for anybody that's been in treatment court or been on probation. And I've had several individuals coming off of the treatment court where we're successful getting the license back. I don't know why, for some reason, this wasn't a successful hearing, but that new standard certainly makes this decision arbitrary, capricious, and I'd ask the court to overturn it and grant him his full license at this time, Your Honor.
Thank you. Ms. Goodrich, I know given the ruling I just made, I might be putting you between a rock and a hard place, but
Sure.
you want to articulate the position, Secretary?
Again, just reiterating, it was the controlled environment of being on probation that caused the denial in this case.
Thank you. Well, in this case, Mr. Rabber successfully graduated from our recovery court program. And we had given him a restricted license that he was driving on with no violations, with an interlock where he had a breathalyzer in the car, no violations. He graduated, well, he goes to the Secretary of State asking for full driving privileges. And in what strikes me as a breathtaking abuse of discretion. I mean, when I read it, I thought I must have read it wrong. That not only did they refuse to give him full driving privileges, they didn't even continue him on the restricted privileges, but revoked his license again when he had not had any violations on the restricted. There was no articulation for any basis to do that, other than the hearing officers discounting entirely Mr. Rabber's sobriety while he was in treatment court. And even though I just made a ruling in another case, I don't know whether the Secretary of State, through the prosecutor, through the Attorney General, will at one of these times appeal one of these. So I need to state on the record the reasons why, again, that I think the Secretary of State is terribly wrong to discount probation sobriety time, especially treatment court probation. Number one, it discounts the effort of the individual by assuming that they are only sober because they are on probation. Many of my probationers do not remain sober. Mr. Rabber used to be one of those probationers. In fact, in this case, it's even more pronounced. I had Mr. Rabber on probation several times in the past, and he didn't stay sober. He stayed sober this time on probation. Was that because of me? No, I'd ordered him to stay sober before, and it didn't work. It was because of Mr. Rabber. He decided to stay sober. The Secretary of State number 2 says they want to see what people can do without the guardrails or structure of probation. That contradicts their general approach that structure is good for recovery. And they don't like lone wolf sobriety. They say you should need the structure and support of, say, an AA or a peer group community. And I agree with them completely. I hope you still go to AA. I hope you do. But for them to then discount the support that probation puts to help people get on a path of recovery doesn't make any sense to me at all. And thirdly, most importantly, especially when you've got specialized probation services like treatment court program, it gives participants a set of tools to help them in their long-term recovery. Discounting the sobriety achieved during those programs ignores the fact that successful participation in such a program is a strong indicator of a stable recovery. Not always. You still have choices to make, and you could go on the wrong path tomorrow. That's up to you. But in study after study and data that Michigan tracks of all the courts in the state, repeatedly and consistently shows that recidivism rates are significantly lower among people who have graduated from treatment courts. So the Secretary of State's approach, particularly in this case, revoking a previously restricted license for a treatment court graduate, is a gross abuse of discretion. It's not supported by competent material and substantial evidence in the whole record. And I do find that it is arbitrary and capricious, and I would reverse it and grant the appeal and direct the Secretary of State to issue full driving privileges to Mr. Rabber. Mr. Kukeski, you can prepare an order.
I do have an order prepared for Your Honor.
Okay. All right.
Or
That's fine too. Okay, now I've got to sign 2 of these. Where they were now. All right, Mr. Keski, I'm gonna have the bailiff tender these back to you for filing and circulation. You may want to see if you can secure the prosecutor's signature as to form. It sometimes gives the Secretary of State more comfort. Good luck to you, Don.
Thank you very much.
Thank you.
All right, Mr. Hartman.
Yes, sir.
We have People v. Coggins, file 25-7109 FH. This is up for
Government
document.
remote?
Yes.